This brings us to the end of our introduction to the power of summons, or the power to summon in criminal proceedings generally, and the beginning of our consideration of one of the types of summons, that is, criminal summons. Who issues a criminal summons? All body or persons authorized by statute to issue a criminal summons. As is our practice, we look at it from the angle of the ACJA, the ACJL, the CPA, and the CPC. First, the ACJL. Section 18, subsection 1J tells us that a superior police officer, as defined by the Police Act, can issue a criminal summons. Sections 113 and 114 tells that a court can issue a criminal summons. But what does the statute mean when it says a court? Please see section 494 sub 1 for the definition or scope of the term court. Let's move on to the ACJL. It tells us that a magistrate or a court can issue a criminal summons. And now let's move on to the CPA. According to section 79 and section 81 of the CPA, a magistrate can issue a criminal summons. And section 80 of the same act tells us that the court can issue a criminal summons. Let's move to the CPC. According to section 47 subsection 1 of the CPC, any court can issue a criminal summons. But sections 47 subsection 2 and 154 subsection 1 tells us that the court or justice of the peace can also issue a criminal summons. But also note that a magistrate can exercise judicial discretion against issuing a criminal summons or warrant of arrest in response to a complaint from a person who believes that there is reasonable or probable cause that an offense has been committed by someone, but he is duty-bound to commit the reasons for such refusal in writing. See section 115 subsection 1A of the ACJA. And in the alternative, a magistrate can exercise his judicial discretion in favor of issuing a summons or warrant of arrest in response to a complaint from a person who believes there is reasonable or probable cause that an offense has been committed by someone, to compel the attendance of such a person before a magistrate court in the district. See section 115 subsection 1B of the ACJA. In either case, section 115 subsection 1 is subject to the provisions of section 89 of the ACJA. What is the position of the law under the ACJL? No similar provision exists under the ACJL, but a similar provision to that which we've just considered under the ACJA exists under the CPA, and it may be explained as follows. A magistrate can exercise his judicial discretion against issuing a summons or warrant of arrest in response to a complaint from a person who believes there is reasonable or probable cause that an offense has been committed by someone, but he is duty-bound to commit the reasons for such refusal in writing. And in the alternative, a magistrate can exercise his judicial discretion in favor of issuing a summons or warrant of arrest in response to a complaint from a person who believes there is reasonable or probable cause that an offense has been committed by someone, to compel the attendance of such a person before a magistrate court in the district. In either case, these provisions are subject to the provisions of section 59 of the CPA. So, section 81 subsection 1 of the CPA gives the magistrate discretion subject to section 59 of the CPA. What is the position of the law under the CPC? No similar provision exists under the CPC. But the question is, does a court that does not have jurisdiction over a matter have the right to issue a criminal summons? What is the position of the law under the ACJL? Even though a court does not have the jurisdiction to try an offense, provided that it has come to its notice that a suspect has been accused of committing an offense, irrespective of the place it was committed, within Nigeria, outside Nigeria, triable in a state, or triable in the FCT, such a court can issue a summons. See Section 113 of the ACJL. What is the position of the law under the ACJL? A magistrate is authorized to issue a summons or warrant if it has come to his notice that the person has been alleged of committing any offense triable in the state, irrespective of the place it was committed, whether within Nigeria or outside Nigeria. See Section 79 of the ACJL. What is the position of the law under the CPA? The CPA is on all fours with the ACJL. In other words, Section 79 of the CPA is equivalent to Section 79 of the ACJL. So what's the position of the law under the CPC? Even though a court doesn't have the territorial jurisdiction to try an offense because the offense was committed in the territorial jurisdiction of another court, provided that the person alleged to have committed the alleged offense is within the territory of the court, then, irrespective of the provisions of Section 134 of the CPC ousting its jurisdiction, and so long as the alleged crime is under any law for the time being enforced triable in northern Nigeria, then the court that ordinarily doesn't have territorial jurisdiction to try the person alleged to have committed that offense shall assume jurisdiction to try that person because of his presence within its territory, and by virtue of the same shall 1. Compel the alleged offender to appear before it, 2. And also try the alleged offender as if the offense was local to his jurisdiction and can send him to the court with territorial jurisdiction over the offense, or, if the offense is bailable, may take a bond with or without sureties for his appearance before such court. Please see Section 139 of the CPC. When criminal summons can be employed? Basically, there are 3 scenarios. 1, to compel someone who is likely not to attend to be present in court. 2, if the law prescribes that summons be used to compel attendance. And 3, if the offense is minor. What is the lifespan of a criminal summons? A criminal summons remains in force until it is executed or until it is cancelled. Therefore, the death, total incapacity, retirement, or removal of the issuing authority does not invalidate a criminal summons. That is the position of the law under the ACJA, the ACJL, the CPA, and the CPC. See Section 139 of the ACJA, Section 100 of the ACJL, Section 103 of the CPA, and Section 383 of the CPC. So what are the contents of a criminal summons? Well, it contains the following. 1, a brief account of the alleged offenses. 2, the name of the alleged offender. 3, an invitation to the named alleged offender to be present in court or at a police station on a given date or time, which shall not be less than 48 hours from the moment of service of the summons on him or her. The date of issue must also be present on the document, as well as the signature of the issuing authority, and it must be made in duplicate. Now let's take a look at each of the statutes. First, the ACJA, Section 117 and Section 112 of the ACJA. The ACJA uses the following expressions. Stating concisely the substance of the complaint is another way of saying brief account of the alleged offenses. Directed to the suspect is equivalent to the name of the alleged offender. Requiring him to appear at a certain time and place is equivalent to invitation to the named alleged offender to be present in court or a police station on a given date and time, which shall not be less than 48 hours from the moment of service of the summons on him or her. Date of issue, please see Section 36 subsection 1A and Section 85 of the ACJA. For signature of the issuing authority, see Section 36 subsection 1C and Section 85. That it must be made in duplicate, see Section 121. Note that the exception to the 24-hour rule or allowance provided for in Section 119, if the complainant swears to an affidavit either at the time of making the complaint or subsequently that the defendant is likely to leave the district within 48 hours. So let's take a look at the ACJL. Sections 82 and 85 are the relevant sections. Stating concisely the substance of the charge is equivalent to brief account of the alleged offenses. Directed to the person or persons charged with the offense is equivalent to the name of the alleged offender. Requiring him to appear at a certain time is equivalent to invitation to the named alleged offender to be present in court or a police station on a given date and time, which shall not be less than 48 hours from the moment of service of the summons on him or her. For dates of issue, see Section 22 subsection 1 and 103 of the ACJL. For signature of issuing authority, see Section 22 subsection 1 and Section 103. Let's move on to the CPA. Stating concisely the substance of such complaint is equivalent to brief account of the alleged offenses. Directed to the person complained against is equivalent to the name of the alleged offender. Requiring him to appear at a certain time and place is equivalent to invitation to the named alleged offender to be present in court or a place or a police station on a given date and time. Date of issue, see Section 22 subsection 1 and 106 of the CPA. Signature of issuing authority, see Section 22 subsection 1 and Section 106 of the CPA. And now, what about the CPC? Section 42 subsection 2. It mentions that it must be in writing, that it must be in duplicate, and that it must be signed or sealed by the court or justice of the peace. It would be good to compare and contrast Section 47 subsection 2 of the CPC and Section 72 of the CPC. There is a relevant case to this matter. It's a British case, Goodman versus Iban J Limited. It's a 1954 British Court of Appeal case. The court considered whether a rubber stamp facsimile of a solicitor's firm on a bill of costs met the requirement for the bill to be signed. The court held that in connection with authentication, it follows, I think, that the essential requirement of signing is the affixing, either in writing with a pen or pencil, or by otherwise impressing on the document one's name or signature, so as to personally authenticate the document. So, the signature can be in the form of writing with a pen or a pencil, or using a stamp. Is the appearance of the accused in court in response to a criminal summons mandatory? Well, for the ACJA jurisdiction, the answer is yes. See section 135 subsection 1, which tells us that if the offense is one for which the accompanying penalty is a fine that does not exceed 10,000 naira, or imprisonment that does not exceed 6 months, or both, and the defendant applies to the court to dispense with his personal attendance, where the offense is punishable by fine or imprisonment or both, or the defendant pleads guilty in writing personally or appears through his legal practitioner who pleads guilty on his behalf. For the ACJL jurisdiction, there is no provision for dispensing with the presence of the accused, since the law is silent on this matter. How about the CPA jurisdiction? If the offense is one for which the accompanying penalty is a fine that does not exceed 100 naira, or imprisonment that does not exceed 6 months, or both, and the defendant applies to the court to dispense with his personal attendance, where the offense is punishable by fine only not exceeding 100 naira, provided that the accused pleads guilty in writing personally or appears through his legal practitioner who pleads guilty on his behalf. What is the position under the CPC? If the accused is represented by counsel and pleads guilty in writing, then we can dispense with his personal attendance at court for the trial. But the above only applies to trial. As respects sentencing, his personal attendance is mandatory. See section 154, subsection 2A and B, and section 154, subsection 3 of the CPC. For the CPA, see section 100, subsection 1. I guess I did not mention that earlier on, of the CPA. For the ACJL, there's no section to check. For the ACJ, section 135, subsection 1. So how does one procure a criminal summons? From a magistrate or judge, and in at least one jurisdiction from a justice of the peace, upon a complaint or information laid before such magistrate or judge or justice of the peace that the person has committed an offense. Execution or service of criminal summons. Basically, there are two ways to do it. Option 1, personal service. That's the best case scenario. Option 2, substituted service. That's the worst case scenario. But one cannot do substituted service without obtaining leave of the court, which means that you can only do substituted service after obtaining leave of court. Execution or service of criminal summons on natural persons. What does the law have to say on this? Service on a natural person, that's an individual, should be done personally. See section 123A of the ACJA, section 87A of the ACJL, section 89A of the CPA, and section 49(1) of the CPC. But if that is not possible, then with leave of the court, substituted service is allowed. And this may be accomplished through pasting its duplicate on some conspicuous part of the premises he resides or works, and the court shall consider the summons served. See Section 124 ACJA, Section 88 ACJL, and Section 90 of the CPA. The provision of the law under the CPC's jurisdiction is slightly different. First of all, there is no provision for obtaining leave of the court to effect substituted service. Second, if he is summoned but he is not seen, then either leave one of the duplicates with some adult male members of his family who should evidence such receipt by signing on the back of the other duplicate, or by pasting on some conspicuous part of the house or homestead of his residence. See Section 52 of the CPC. Note that it can only be left with an adult male member of his family, not an adult female member of his family. Note also that pasting at his workplace is not allowed by the CPC. In all jurisdictions, there is a provision for acknowledgement of service of summons. See Section 128 subsection 1 of the ACJA, Section 92 subsection 1 of the ACJL, Section 94 of the CPA, and Section 49 subsection 2 of the CPC. Failure to acknowledge receipt of a summons is an offense, and so he can be arrested and brought before the court that issued the summons, and detained or imprisoned for a maximum of 14 days. See Section 149 of the ACJA. How about the ACJL? Failure to acknowledge receipt of a summons is an offense, and so he can be arrested and brought before the court that issued the summons. However, unlike the ACJA, in the ACJL, there are no stipulations or limitations, so the court has discretion, for example, to hold him forever. See Section 93 of the ACJL. The position of the law under the CPA is the same as obtains under the ACJA. He can be arrested and brought before the court that issued the summons. He can be detained or imprisoned for a maximum of 14 days. The CPC does not have a similar provision, although it has provisions relating to the inability of a person served to sign or seal, and the law is to the effect that if a person served or left does not have the capacity to sign or put a mark on the same, such a summons should be served or left in the presence of the witness. See Section 53 of the CPC. If the natural person or individual to be served happens to be a government employee, then under the ACJA, the court issuing the summons may send it in duplicate to an officer who heads the department the person happens to be employed with, if it appears to the court that it may be most conveniently so served. See Section 125, subsection 1 of the ACJA. And the head of the department, that is the officer in charge of the department, should, on receiving the summons, direct its service on the employee in accordance with the provisions of Section 123A of the ACJA, and shall thereafter return the duplicate under his signature with the endorsement required by Section 115 of the ACJA, which signature shall be evidence of the service. See Section 125, subsection 2 of the ACJA. Please note that the ACJA calls a government employee a public officer. How about under the ACJL? Well, the court issuing the summons may send it in duplicate to the director or head of the department the person happens to be employed with, if it happens to the court that such is the most convenient form of service, and the director or head of the department should, on receiving the summons, direct its service on the employee in accordance with the provisions of Section 87A of the ACJL, and shall thereafter return the duplicate under his signature with the endorsements required by Section 92, which signature shall be evidence of the same. The ACJL calls a government employee the person summoned is in the service of the government. How about under the CPA? The court issuing the summons may send it in duplicate to the head of the department or person that he happens to be employed with, if it appears to the court that it may be most conveniently so served. The head officer of the department should, on receiving the summons, direct its service on the employee in accordance with the provisions of Section 89A of the CPA, and shall thereafter return the duplicate under his signature with the endorsement required by Section 93, and such signature shall be evidence of the service. The CPA calls the government employee the person summoned is in the service of the government. So what is the provision of the law on the execution or service of criminal summons on artificial persons? We'll take them one by one. Corporations. Section 123B of the ACJ tells us, 1. It can be served on one of the partners. 2. To a director. 3. To the secretary. 4. To the chief agent within the jurisdiction. 5. By leaving it at the principal place of business in Nigeria of the firm or corporation. And 6. To anyone having, at the time of service, control of the business of the firm. What does the ACJL have to tell us? In Section 87B, it tells us that 1. To one of the partners. 2. To a director. 3. To the secretary. 4. To the chief agent within the jurisdiction. 5. To anyone having at the time of service control of the business of firm or corporations. And 6. By leaving it at the principal place of business in Nigeria of the firm or corporation. How about the CPA? The CPA is on all fours with the ACJA. See Section 89B subsection 1. So 1. One of the partners. 2. To a director. 3. To the secretary. 4. To the chief agent within the jurisdiction. 5. By leaving it at the principal place of business in Nigeria of the firm or corporation. And 6. To anyone having, at the time of service, control of the business of the firm. How about under the CPC? 1. To the secretary. 2. To the local manager. 3. Other principal officer of the corporation at any office of the corporation in northern Nigeria. See Section 50 of the CPC. And what if the artificial person is a local government council? Then according to the Section 123C of the ACJA, in accordance with the LGA law. Under the ACJA, according to Section 87C of the ACJL, in accordance with the appropriate provisions of the LGA law operating in the state. How about on the CPA, according to Section 89C of the CPA, in accordance with the LG law of the state. How about under the CPC, according to Section 51 of the CPC, in accordance with the provisions of the Native Authority law. And what if the artificial person happens to be the Nigerian police? Then Section 153D of the ACGA tells us that at the federal level, the IGP, at the state level, the Commissioner of Police of that state or the FCT. Please note that the ACJL, the CPA, and the CPC are silent on an artificial person that happens to be the police. What if the artificial persons happen to be a federal government ministry, department, or agency? Section 153E of the ACJA tells us to the Attorney General of the Federation or to the legal department of such a ministry, department, or agency. The ACJL is silent, the CPA is silent, and the CPC is silent on an artificial person who happens to be a federal government MDA service of summons. And what if it happens to be a state government agency, ministry, department, or agency? Section 153F of the ACGA tells us to the Attorney General of that state or to the legal department of such an MDA of the state. All the other statutes, the ACJL, the CBA, and the CPC are silent on service of summons on an artificial person that happens to be a state government agency. How about if the artificial person happens to be any arm of the armed forces? Section 123G of the ACGA tells us to the Director of Legal Services of the service or command concerned. The ACJL, the CPA, and the CPC are silent on this kind of artificial person. So what does the law have to say about the service or execution of criminal summons inside or within the state of issue? Well, if we have two courts within the same state but are situated in different jurisdictions, where one court is the issuing court, that is the court that issued the criminal summons, and where the other court is the receiving court, that is the court that has territorial jurisdiction over the place of residence or work of the offender, then the issuing court will send a duplicate of the summons to the receiving court. See Section 126 of the ACJA, Section 91 of the ACJL, Section 92 of the CPA, and Section 54 of the CPC. Thereafter, the receiving court will then assume all the powers of the issuing court with respect to directing service of the transferred summons. Additionally, under the ACJA, Section 126 of the ACJA provides as follows. Where a court issues a summons to a person outside its jurisdiction, the summons shall be sent in duplicate to a court in whose jurisdiction the person resides or works. How about under the ACJL? Section 91 of the ACJL provides as follows. Where a court desires that a summons issued by it shall be served at any place outside the jurisdiction in which it is issued, the court shall send such summons in duplicate to a court within the jurisdiction in which the person summoned resides or is to be served. Remember, it's Section 91 of the ACJL. How about under the CPC? Well, Section 92 of the CPC tells us that where a court desires that a court summons issued by it shall be served at any place outside the division or district in which it is issued, the court shall send such summons in duplicate to a court within the division or district in which the person summoned resides or is to be there served. How about under the CPC? Section 54 of the CPC tells us that a summons required to be served outside the local limits of the jurisdiction of the court or justice of the peace issuing it shall ordinarily be sent in duplicate to a court within the local limits of whose jurisdiction the person summoned resides or is there to be served. So how about execution or service of criminal summons on information or complaint outside the state of issue? It appears that the ACJA is silent on this. However, according to the Section 364 of the ACJL, if the summons is to be served on a corporation outside the state of issue, or the summons is issued under the ACJL on information or complaint, but not a summons meant to compel the attendance of a witness, then even though it is issued in one state, that is the issuing state, it may be served on the addressee, resident or working in another state, without the necessity of obtaining the endorsement of a magistrate of the other state, that is the state of execution. The service of such summons in the state of execution will be carried out in the same manner as such service would have been carried out in the issuing state. The subject to the summons is served is required to acknowledge service of the said summons by endorsing the duplicate copy. In such circumstances, service of the summons may be proven as follows. 1. By affidavit sworn before any magistrate or justice of the peace having jurisdiction in the state in which such service was effected, or in any manner in which such service may have been proved if it had been effected within the state in which the summons, subpoena, notice, or process was issued. The CPA has a similar provision in section 478. That section has 5 parts. According to section 478 of the CPA, if the summons is issued under the CPA on information or complaint, but not a summons meant to compel the attendance of a witness, then, even though it is issued in one state, that is the issuing state, it may be served on the addressee resident or working in another state, without the necessity of obtaining the endorsement of a magistrate in the other state. That is the state of execution. The service of such summons in the state of execution will be carried out in the same way as such service would have been carried out in the issuing state. The subject the summons is served is required to acknowledge service of the said summons by endorsing the duplicate copy and failure of the person on whom service was effected to enter in an appearance is not fatal to the proceedings if the court can establish that service was effected a sufficient time before the time specified for the proceedings to hold. In such circumstances, service of the summons may be proven as follows. 1. By affidavit sworn before any magistrate or justice of the peace having jurisdiction in the state in which such service was effected, or in any manner in which such service might have been proven if it had been effected within the state in which the summons, subpoena, notice, or process was issued. See section 481A and B of the CPA. Just like the ACJA, the CPC is also silent. And as for how to prove the service of a criminal summons on information or complaint outside the state of issue under the ACJL, the two methods, please check section 364. Service of criminal summons such as witness summons outside the state of issue. Please note that the ACJA is silent on this. According to the ACJL in section 365 specifically, if the summons to be served is any other form of summons such as a summons meant to compel the attendance of a witness or witness summons for short, then the only authorized manner of service in the state of execution is by leave of court. Let's analyze the 3 subsections of section 365 below. First of all, let's take section 365 subsection 1. If a warrant for the arrest of a person, that is a warrant for arrest for short, has been issued by a court, a judge, a magistrate, or a justice of the peace of the issuing state in accordance with the ACJL, then the magistrate of another state, being a state in or on his way to which the person against whom the warrant has been issued is or is supposed to be, that is the state of execution, shall, after confirming its authenticity, make an endorsement on the warrant in the form or to the effect of the form in the forms authorizing its execution in that other state. Let's take on section 365 subsection 2. Such a warrant endorsed by the magistrate of the state of execution is sufficient authority to 1. The person bringing the magistrate, 2. To all police officers, and 3. And persons to whom the warrant is directed, and then 4. And to all police officers in that other state to execute the warrant in that other state, to arrest the person against whom the warrant was issued, and to bring that person before a magistrate of that state. Note, other states, and that state all mean the state of execution of the warrant of arrest. Now, let's take on the last subsection, section 365, subsection 3. The magistrate of the state of execution before whom the person is brought shall A. By his warrant under his hand, order the person to be returned to the state in which the original warrant was issued. That is the issuing state. And for that purpose, be delivered into the custody of the person bringing the warrant, or of a police officer or other person to whom the warrant was originally directed. Or B. When the offense charged is an offense in respect of which he may admit the person to bail, admit the person to bail on such recognizances as he thinks fit, on condition that the person appears at such time not exceeding 1 month after the date of the order admitting him to bail, and at such place in the state in which the original warrant was issued, that is the issuing state, as the magistrate specifies, to answer to the charge or to be dealt with according to the law. The CPA has a similar provision in section 479. Unlike the ACJL, that section has 4 parts. If the summons to be served is any other form of summons, such as a summons meant to compel the attendance of a witness or witness summons for short, then the only authorized manner of service in the state of execution is by leave of court. Let's analyze the 4 subsections of section 479 below. It uses the expression subpoena and summons interchangeably. It gives some of the reasons that the court may issue either as follows: 1. Requiring any person to appear and give evidence. 2. Requiring any person to produce books or documents. Now let's take on the first part. It states that if the court, judge, or magistrate is satisfied that it is in the interest of justice, then such court, judge, or magistrate can issue either and has the discretion to give terms governing its execution. See section 479 subsection 1. It provides that if a person becomes a witness to a matter at any court of a state, then a notice of the hearing or trial of the case in respect of which he is bound may be served on such person in any other state. See section 479 subsection 2. If a person upon whom a subpoena, summons, or notice of hearing has been served in accordance with section 479 subsection 1 fails to attend at the time and place stated in such subpoena, summons, or notice of hearing, then such court, judge, or magistrates in the state of execution may, after confirming the authenticity of evidence that the person was indeed served, thereafter issue such warrant for the apprehension of such person as if such court, judge, or magistrate was the original author of the subpoena, summons, or notice of hearing, and the state of execution and the issuing state were one and the same. See section 479(e)(3). Such warrant may be executed outside the state of issue, that is the state of execution, in accordance with this chapter of this Act, with respect to warrants issued for the apprehension of persons charged with an offense. See section 479 subsection 4. So what are similarities between a criminal summons and a warrant of arrest? Once issued, both remain in force until it is either executed or cancelled by the judge or magistrate. And that's the provision of the law in all 4 jurisdictions: section 39 subsection 2 and 139 of the ACJA, section 25 subsection 2 and 100 of the ACJL, section 25 subsection 2 and 103 of the CPA, section 56 subsection 2 and 383 of the CPC. So, what is the difference between criminal summons and a warrant of arrest? While a criminal summons is addressed to the accused, a warrant of arrest is addressed to a police officer or officers mandated to arrest and bring the person named therein before the court that issued the same. Please see Section 39 subsection 1 of the ACJA, Section 25 subsection 1 of the ACJL, Section 25 subsection 1 of the CPA, Section 58 subsection 1 and 59 of the CPC. Which comes first, a summons or a warrant of arrest? We're not going to answer this question. This is a take-home assignment. If you truly understand what we have discussed so far, it should be possible to answer this question, because it provides a possible basis for a fact pattern or scenario-based exam question. Acknowledgements of service of summons, or alternatively, how to prove service of summons. The answer depends on the method of service. If the service was personal, then irrespective of whether the direct addressee or another person substituted for him, the person signing for it shall acknowledge receipt at the back of the duplicate. This is the position of the law in all 4 jurisdictions. Now the relevant sections are Section 128 subsection 1 ACJA, Section 92 subsection 1 ACJL, Section 94 CPA, Sections 49 subsection 2 and 52 of the CPC. If the service was by substituted means, then the person effecting the service shall endorse on the duplicate particulars of the method by which he effected such service. This appears to be the position of the law in 3 jurisdictions. Please see Section 128 subsection 2 of the ACJA, Section 92 subsection 3 of the ACJL, Section 94 of the CPC. How about under the CPC? Whether the service was personal or by substituted means, the CPC allows for acknowledgments by way of witness testimony in addition to the endorsed duplicate copy of the summons. Section 53 of the CPC allows for the summons to be served or left in the presence of a witness if the direct addressee or the person substituting for him cannot sign for it or make his mark. Section 55 of the CPC states that an affidavit or declaration purporting to be made before a court by the serving officer or by a witness to the service that a summons has been served and a duplicate of the summons purporting to be endorsed in manner provided by Section 49 of Section 52 of the CPC by the person to whom it was delivered or tendered or with whom it was left shall be admissible in evidence, and the statements made therein shall be deemed to be correct unless and until the contrary is proved. Note, affidavit to declaration will detail why this method of service had to be utilized and how the substituted service was achieved. How does one prove service of summons in the absence of the serving officer? Well, in 2 jurisdictions, The position of the law is identical. That's the ACJA and ACJL jurisdiction. Section 127 of the ACJA and Section 90 of the ACJL both state the position of the law to be that in the absence of the officer who served the summons, at the hearing of the case, proof of service can be achieved by 1. Endorsement on a duplicate of the summons, and 2. An affidavit showing when and how the service was effected. The position of the law under the CPA jurisdiction is a little different. Rule number 1. In the absence of the officer who served the summons at the hearing of the case, where both the issuing court and the court of execution share the same jurisdiction, that is the same division or district, then proof of service can be achieved by endorsement on the duplicate of the summons. See section 93 subsection 1 of the CPA. Here's the second rule. In the absence of the officer who served the summons at the hearing of the case, where the issuing court and the court of execution are in different jurisdictions, that is different divisions or districts, then proof of service shall be by an affidavit made before a magistrate or other prescribed person, and such endorsement and affidavit shall form part of the record. See section 93 subsection 1 of the CPA. But taking care that the endorsement and affidavit show the manner in which such summons was served, and as respects the affidavit attached to the duplicate of the summons and returned to the issuing court. See section 93 subsection 2 of the CPA. Please note that in the CPC jurisdiction, the law is silent. Substituted service of summons, conditions precedent to. The general rule in 3 jurisdictions is that substituted service can only be resorted to if the following conditions are true. 1. Personal service is impossible. 2. The court so permits, that is with leave of the court. See sections 124 of the ACJA, section 88 of the ACJL, and section 90 of the CPA. The general rule in CPC jurisdiction is that substituted service can be resorted to if personal service cannot be resorted to, but no leave of court is necessary. See section 52 of the CPC. How does one effect substituted service in Nigeria? In 3 jurisdictions, by pasting one of the duplicates on some clearly visible part of the residence or workplace of the person being summoned. See section 124 of the ACJL, section 88 of the ACJL, and section 90 of the CPA. In CPC jurisdiction, by 1. Leaving one of the duplicates with some adult male members of his family, who should evidence such receipt by signing the back of the other duplicate, or 2. By pasting on some clearly visible part of the house or homestead of his residence. Please note that it cannot be left with a female adult or child. It can only be left with an adult male member of his family. Also note that pasting at his workplace is not a recognized means of effecting substituted service under the CPC. Please see section 52 of the CPC. In slide 3, we indicated that in 2013, a judge of the High Court of the FCT ordered then-President Goodluck Jonathan to appear before it as a witness in a forgery trial involving 3 journalists. We also raised the question, was that a legitimate exercise of judicial authority? Let the Constitution help us to answer that question. Section 308 subsection 1a tells us that no civil or criminal proceedings shall be instituted or continued against the person to whom the section applies during his period of office. Section 308(1)c tells us that no process of any court requiring or compelling the appearance of a person to whom this section applies shall be applied for or issued. Section 308 subsection 2 states the exception as including civil proceedings against the person to whom this section applies in his official capacity, or to civil or criminal proceedings in which such a person is only a nominal party. Section 308 subsection 3 specifically includes the office of president. Since Goodluck Jonathan was president between 2010 and 2015, and that case was a 2013 case, that, with due respect to the Honorable Judge, was not a legitimate exercise of judicial authority. In slide 4, we discussed the summons issued against the then Chief Justice of the Supreme Court of Nigeria early in 2019 and raised the following questions. What is meant by the expression properly served with summons? Proper service of summons on an individual may be personal or substituted. However, law is procedural. For service to be proper, one must be strictly guided by the provisions of the statutes or service of summons. Please review the headings: Service of Summons on Natural Persons, Acknowledgement of Service of Summons, Substituted Service of Summons, Conditions Precedent to, Substituted Service of Summons, How Effective, for full details of the technicalities. Is it mandatory that the summons must be personally received by the person therein named? Yes, if the court asked the person to be personally served. No, if the court gave leave for substituted service. No, if the service is in a jurisdiction that doesn't require leave of court for substituted service. Can summons be said to be improperly served if the person named therein nominates another to receive the summons on his behalf? Yes, if the court ordered substituted service. No, if it is done under the CPC jurisdiction. Please review the subheading Substituted Service of Summons, Conditions Precedent to. In slide 5, we asked who can order the service of a summons on someone. Please refer to the subheading Who issues a criminal summons for the answers. What is a criminal complaint? Basically, an allegation that someone has committed a crime or is in the process of doing so. Who can make a criminal complaint? Well, just about anyone, literally. To whom can one make a criminal complaint to? A magistrate, a judge, or a justice of the peace? Who can serve court papers on an accused? A process server. Who can order the issuance of a summons on an accused? The court. What is a witness summons? A summons that is issued to compel the attendance of an individual to appear and give evidence or produce books or documents or things that will aid the court in its determination of the case. That FCT High Court judge issued a witness summons against the former president, Goodluck Jonathan. How is a witness summons different from a criminal summons? A criminal summons assumes that the person invited is also the accused, as opposed to a witness summons that assumes that the person invited is not the accused but is aware of the crime and or the accused in relation to the crime. What is a warrant of arrest and when is it used? We will treat that when we treat arrests. Can you draft a charge based on the criminal complaint against the former Senate President? In slide 6, we took a look at how the court ordered substituted service of fraud charge on Uwaje and raised the following questions. What is a criminal summons? Please refer to our definition of the term under summons defined, which explains in detail. However, in one sentence, a written, not oral invitation to appear before the court to respond to a charge or charges against the person. On what basis did Justice John Soho issue a criminal summons against Victor Uwaje? On the grounds of the allegation that Mr. Uwaje tried to obtain money from Andy Uba through fraudulent means. If personal service on the accused is impossible, how otherwise might service be effected? By substituted means. Please see the following sections. Substituted service of summons, conditions precedent to, and substituted service of summons, how effected. Are there any consequences for an accused who evades personal service? Yes, there are. Please refer to the heading, Effects of Disobedience to a Summons. What is the correlation between the grant of leave and the service of a criminal summons through substituted means? There must be a grant of leave of court before service through substituted means. In slide 7, we discussed the court summons against the current Speaker of the House of Representatives, Femi Gbajabiamila, which was subsequently withdrawn. Can an accused challenge a summons? Yes, the accused in that case successfully challenged the summons by raising the issues of the jurisdiction of the area court to entertain that case and by requesting judicial review from the High Court of the FCT. Why did the FCT High Court quash the summons of the Grade 1 Area Court? Because the accused asked that court to judicially review the proceedings, decision, criminal charge, and order of the Grade 1 Area Court on the grounds that the Grade 1 Area Court doesn't have jurisdiction, and to stay further action or proceedings of the Grade 1 Area Court. The basis for the action of a judge or magistrate to issue a criminal summons is a complaint. See a sample complaint form taken from the ACJA. Recall that an Abuja-based lawyer and rights activist, Oluwatosin Ojamo, initiated a criminal complaint against the former Senate President. This is the kind of form that would have been used if the complaint was acted on by the court. Recall that the former Chief Justice of Nigeria was summoned to appear before the Code of Conduct Tribunal, and also that the former Senate President was also summoned. Given that both cases were before federal courts, the current slide shows a picture of what the summons to a defendant must have looked like. While discussing the court-ordered substituted service of fraud charge on Uwaje, we asked if there are any consequences for an accused person who evades personal service. The answer is yes. A warrant for arrest of a defendant who has disobeyed summons can be issued by the court. The court can order the police to produce a defendant before it using the form shown on the screen. The judge of the High Court of the FCT, Usman Musale, who ordered the then President Goodluck Jonathan to appear before it as a witness, must have used the kind of form currently shown on the screen. It's called summons to witness. Although that case was a 2013 case, which means that the operative law was not the ACJ, if that case were conducted today, then the case would have been conducted under the ACJ, and the form shown on the screen would have been used. In the last few weeks, the internet has been awash with news that Naira Marley's entourage stole someone's car who had a road traffic incident with one of the vehicles in his convoy. Given that it happened in Lagos, where the ACJL holds sway, this is the form the court would issue to order him to appear as an accused. Assuming he was served, but he decided not to appear in court, the court could decide to issue a warrant for arrest of defendant who has disobeyed court summons, as is shown on the screen. There is a slight difference between a summons to a defendant and a summons to a witness. The current slide displays a summons to a witness under the ACJL. Failure to respond positively to a witness summons leaves the court with no choice than to issue a warrant for the arrest of a witness. See a copy of the same on the screen from the ACJL. This is a slightly different version of a warrant for the arrest of a witness. This one is called a warrant for arrest of a witness in first instance. We have already explained the role of complaints in the criminal trial process. The screen is currently showing a sample of the form of complaint used under the CPA. The court can order the presence of an accused using the form of summons to a defendant currently showing on the screen within the CPA jurisdiction. If the defendant disobeys the summons, the court reserves the right to issue a warrant for his apprehension. The screen currently shows the applicable form for the CPA jurisdiction. The current screen shows the CPA jurisdiction's version of a warrant for the apprehension of the defendant in the first instance. The slide shows the CPA's version, the CPA jurisdiction's version of a summons to a witness. The slide shows the CPA jurisdiction's version of a warrant for the apprehension of the witness. Please note that we do not have a copy of the forms for the CPC jurisdiction, otherwise we would have created slides for those. That brings us to the end of our consideration of criminal summons under Nigerian criminal law.